And now we're on to the next case. Please raise your right hand. Plaintiffs Michael Green and Wesley Gadsden are suing their former tenants for rent and eviction fees. Defendants James and Ricky Griffin say the plaintiffs caused their situation.
Mr. Gadsden and Mr. Green, it would appear that you two are business partners, and amongst other things, you rent rental properties. We're talking about a 6-bedroom, 3-bath home that you allegedly rented to the defendants, Mr. and Mrs. Griffin. It was a 1-year lease, and you say that the defendants became delinquent and you had to proceed with eviction proceedings which were successful. Is that right? Now you're trying to collect the past due rentals. Let's see, Mr. and Mrs. Griffin, you say that in effect Mr. Griffin had a health problem that rendered him disabled, and there was assistance applied for, but you were evicted before the proceeding was completed, and had the eviction not occurred, they would have gotten their money. Is that your defense?
Yes, sir.
All right.
Judge, we entered into a lease agreement with the defendants back in November of 2009. And just to give an example of the blatant level of irresponsibility that the defendants have, we allowed them to move in 1 month early in October. 3 times their deposit checks bounced. I then went further and opened up a special account for the defendants to make it easy for them to deposit their money into the account. They never did. It got to the point where we required that they pay cash, a cashier's check. Not once did the defendants pay rent on time. September was the last time we received any money from them, and that was $600, and that was 2 weeks after the first.
That's quite a bit less than the monthly rental would appear to be. What is it, $15.95 per month?
Yes, Your Honor.
So, you want your money. You're showing that there is, according to your sworn accounting, there's $4,185 for 3 months worth of back rentals, and $545 you see compensation for eviction fees. Is that right?
That is correct, Your Honor.
All right. You made out a prima facie case. Let's go to the defendants. What's your defense, please?
Well, Judge Joe Brown, he hasn't told the whole truth. Well, the problem is that in July, I did have a kidney transplant. Along with that, in May of that year, a young lady that we were trying to assist, she dropped off 3 infants, small kids on us, right after I found out that I needed a kidney transplant. I had taken medication, and I found out that I was at stage 4 of kidney disease. So ultimately, I ended up needing a kidney transplant, and a young man that I had encouraged years prior came back to Minnesota, and he volunteered to actually give me his kidney. So ultimately, it was set up for July. The young lady was supposed to pick her kids up prior to that, but we ended up having to deal with an abandonment issue. We set up the funds in order to carry us through the process.
We'll be back with more Judge Joe Brown in a moment.
In July, we went to Memphis, Tennessee to return these 3 children that were left with us. That's why we went. We didn't go on vacation. We went to return the 3 children. As I just stated, Judge, I'm not talking to you.
Plaintiffs in this case say they rented a house to some new tenants who were always late on the rent. They feel they gave the family plenty of chances before they were forced to seek action. Let's get back to the case.
Please continue.
So I called Mr. Gantz, and I told him we were doing some things trying to come up with the balance that we had to pay. And so we went and get some assistance to pay our back finances, our back rent. And we told Mr. Ganson that we needed a letter from him. The letter needed to state exactly what we owed and exactly how much we had to pay. Well, Mr. Ganson, instead, I gave him the information, and I gave him the phone number. I told him we needed a letter. Instead, he called the state And when he called them, quite naturally, they were not going to disclose any information. I didn't need him to call. I needed him to give a letter. A week later, he calls me back and says, well, what are you going to do about the rent? And I said, well, I needed that letter. That is so finally, what he did was, then he turns around and he drops the letter. He said, well, I'll have Mike to drop it off at the house. So finally, they leave the letter at the house. I take the letter down to the state. It states that he's not going to renew the lease, and he might give you a month-to-month. And he says, and they said that's the only reason.
Read that letter, James. Read that letter verbatim.
As I stated, Judge Gibran, as I stated,
Somebody pass me up a copy of the letter, please. Thank you, Madam Sumner.
Okay. So he gives us this, we get the eviction notice, and we get it on the 27th of October, and it says that they want the full amount on the 1st. And when I spoke to Mr. Ganson on the phone, I told him, there's no way physically possible, since I just went back to work, that I could pay $4,000 on the 1st, and I just went back to work. I said, but we were working on something. He said, well, no, I need this by the 1st, and if not, you guys have to move. And we even when we went to court for the eviction notice, we spoke to Mr. Ganson and told him that we're going to do the best we can. And so it's not like we're trying to bail out. That is a blatant lie. It's not.
Stop. Keep going, please.
Thank you, sir. It's not as if we were trying to bail out. The problem is that we were placed in a no-win situation. So therefore, the state would have covered that. The problem is that because he issued those particular documents, they bagged out.
Was it before your vacation or after?
And so actually what they did was, Your Honor, they turned around and they gave us the help that we needed, but the problem was they were not going to pay that back money. And as far as Mr. Ganson talking about the vacation, in July, we went to Memphis, Tennessee to return these 3 children that were left with us. That's why we went. We didn't go on vacation. We went to return
That's not
the
what
3
you told
children.
me.
As I just stated, Judge, I'm not talking to you. As I was stating, Judge Gibran, is that we went and we were returning the kids, and the mother did not show up. So we're stuck with these abandoned children, and we're trying, out of our compassion, even though I'm sick and can't even care for myself, but yet we knew these kids couldn't be left with nothing. And so that's why we're actually was placed in a predicament that we're placed in.
Judge Joe Brown makes his ruling.
All of that's well and good, but it doesn't operate as a defense to an ancient matter of property rights. It's about 1,000-year-old law, and it hasn't changed in that part of the equation. It's a free society that leaves people to their own devices is what applies here. And unless they were as nice about it as you are in demonstrating your charity to the unfortunate, then you're stuck with what they wound up doing. They had ample legal basis to get you out of there. They proceeded with an FED, that's a forcible entry and detainer, with the appropriate state courts with appropriate jurisdiction. That's res judicata, which means the thing has been resolved and cannot be undone. The same rights that are inherent in their right to possession are also inherent in their rights to collect past due rentals, which is what we're here for arbitration to resolve. So you have no legal defense, and you will get your requested recovery reduced to an award of $4,730 in your cost.
And this courtroom is now in recess. The defendant's new kidney gave him a new lease on life. Good stuff. He's still responsible for that old lease with the Titus. The Titus brand. We'll be right back.